Donald Trump gets a gag order from Judge Chutkan. She's presiding over the January 6th prosecution brought by special counsel Jack Smith. And we're still waiting for the details on the final order that is to be written. But we see from the court proceedings that she has made her decision. She says that the order is forthcoming, but here it's going to be delivered soon. Everybody was present at the proceeding. John Lauro, Todd Blanche, Molly Gaston, and Thomas Wyndham were all there. So we don't have any details from this minute entry, but the order will be forthcoming. But fortunately, we do have somebody who was there inside the courtroom who's going to be guiding us through what happened at the hearing. You remember him as Roger Parloff. He's done some other very good reporting on some other trials, like the Proud Boys trial. And he was there in the courtroom during the Trump gag order hearing today, bringing us details from inside. He's reporting. Roger Parloff on the X. He says, bright and early this morning, I'm at E. Barrett Prettyman, U.S. Courthouse this morning, and we're going to be tweeting the hearing, United States of America versus Donald Trump. Now, he's done us a solid and given us a key excerpt of the gag order, of the protective order that Jack Smith is seeking. And remember, Jack Smith doesn't want Trump to get on True Social and say, this entire prosecution is illegitimate. And Jack Smith is an employee of the DOJ, which is Joe Biden's office, and they've been prosecuting me 4 times now. The special counsel, 2 cases, Florida and D.C., but many conversations about them guiding Big Fannie Willis's case out of Georgia, and a bunch of overlap with Alvin Bragg and some coordination with the DOJ and so on, as they maneuver their cases around to prosecute Trump. So Trump, as not only a defendant, but as a presidential candidate, has multiple layers of free speech, right? Free speech to talk about his position as a defendant, but also free speech as a candidate to talk about how disgusting the Department of Justice and the DC Circuit has become. Don't you want to reform that as a political candidate? Shouldn't he be able to talk about weaponized political prosecutions, many of which we've covered here, that involve the Proud Boys, for example, going to prison for 18 years, or the Oath Keepers for 22 years? It's insane. So surely he should be allowed to comment on that. But no, Jack Smith wants his butt gagged, and sounds like he's going to get it. So here's the proposed order from Jack Smith. This is what he wants the judge to sign off on. Has not been signed off on yet, but we're going to be debating this throughout the hearing. He says that the parties in this case, Judge Chutkan should sign off on this, are prohibited, their attorneys too, Trump and his lawyers, from making or authorizing statements to the media or in public settings, including on social media, that pose a substantial likelihood of material prejudice to the case, whatever that means. Such statements include, but are not limited to, statements regarding the identity, the testimony, the credibility, okay, somebody's a garbage hack prosecutor or something like that would attack their credibility, of prospective witnesses, or disparaging or inflammatory or intimidating statements about any party or witness or attorney or court personnel or potential jurors. So Jack Smith also wants his fee-fees protected because he's feeling a little bit sad. The defendant is also prohibited from causing surrogates to make such statements on his behalf. Okay, so Trump can't tell his other people to go out there and talk about this as a third party, which means we're just going to have to increase the volume here. Okay, we're going to have to just call this even more illegitimate, even harder, and we're going to have to call this a hack partisan political prosecution even louder, man. And I'm going to ask you to share it even harder and harder and harder so that everybody realizes what a joke this political prosecution actually is. Not only are they prosecuting their opponents, but now they're trying to gag them as well, and they're probably going to do it. He says, we're now in the media courtroom. Activity starts to bubble up. There are actually 2 media rooms. There are 2 screens, each in 4 quadrants. We've got the 4 quadrants on the screen. One's on the judge's bench. The other is different parts of the courtroom. The last is for exhibits. So 2 different angles of the courtroom. We got the judge and the overhead for the documents. At the defense table, we got the Trump defense team, John Lauro, Todd Blanche, Greg Singer, the new lawyer, Emil Bove, and one additional man who may be a paralegal or associate. So we've got 5 people there suited up, ready to go. Big issue, big case. It's the president. It's free speech. It's a criminal prosecution. Bove is the recent addition. We saw his notice of appearance filed. He's the former head of the National Security Unit of the Southern District of New York. Ooh, a pretty heavy hitter, they say. Now, we can't see the prosecution table at the moment, but there's probably going to see them soon. The lead on the motion so far has been Molly Gaston, the highlighter girl from the Department of Justice, and Thomas Wyndham, as we've seen before. We've got a lot of activity. Now they're reporting over from Lawfare. So what they say, the judge now comes out. It's 10 a.m. She's got her coffee. She comes out, door opens. All rise. Oh. All right, please be seated. Judge Chutkan comes out. Good morning, everybody. Happy Monday. Okay, so what do we have first on the docket here today? I am looking at this order. All right, so Jack Smith is here. We're on the case of United States of America versus Donald Trump. Parties' appearances, please. Here, Your Honor, for the government. Here, Your Honor, for the defense. What do we have here? I'm looking at Mr. Molly Gaston from Jack Smith's office. I'm looking here at an order. It is apparently you're trying to restrict an out-of-court statement. It looks like you want to prohibit all parties from making or authorizing statements, including through social media. I'm reading it here for you. She says, but first, I want to discuss something that's even less controversial. Previously in this week, we talked about survey practices for juror members. Remember that? She points over to the government. And just to catch us up, last week, part of the original request from Jack Smith was that he doesn't want Trump to go out and do jury focus groups, right? You know, focus groups, you go, did you like that movie or not? Did you like how that candy bar tasted or not? Kind of those things. You can do that with jurors. Did you like this opening statement? Did you like when I called him this language? Did you like when I emphasized his relationship with his son or daughter or not? And so you can try out a bunch of different things. Jack Smith was trying to limit Trump's ability to do that. So Chutkan comes out and she's maybe going to throw Trump a bone here before she gags him. She's going to say, well, we're going to, she says, I'm kind of skeptical that we need restrictions on these, like jury surveys. Like, how is that even necessary? And, this is what the government does. They have a main attempt. They want Trump gagged, and they also don't want Trump to use, pick something. How about jury surveys? And so when the judge denies their request on the jury surveys, which they don't give a crap about, then she'll say, see how fair I was? Now you can go do jury surveys. And Trump's people are going to be like, okay, that's amazing. Thank you for that. We would prefer if we could, speak and not be gagged. She's going to kind of, have a split motion, and it's going to feel like she's very fair and not. She's going to gag him on the free speech and then throw away this jury survey crap. And Molly comes out, well, Your Honor, we were concerned that questions in the study might actually prejudice the jury pool, which is the most asinine argument. That's how you know this argument is ridiculous. So, okay, Molly, you really think that Donald Trump is going to do so many jury surveys, right? He's going to just blanket all of Washington, D.C., that it's going to hit such a large percentage of the potential jury pool that it's going to impact and prejudice the jury pool. Hear how insane that is? How many jury focus would Trump do? 1,000? No, of course not. It's like 3. You do like 3 of them, right? Or you do like 1 a week, test them out. And let's try this. Let's try this. Let's try this. It's not like you're doing thousands of these to program all the D.C. jurors. But she's saying, well, we're concerned that the questions in the study might prejudice the jury pool. Like if we're getting a bunch of, surveys and polls going out. It's ridiculous. It's a throwaway argument. They all know it is. This is just performative right here. So the judge says, well, I think defense's proposals are sufficient for protection at the moment. So we're going to deny the government your limitation for those additional jury protections. And Molly's like, oh, shucks, Judge. Oh, you ruled against us. Man, this stinks. And it's obviously just meaningless. So she says, now I'm not going to micromanage survey requirements. And the government didn't care about it anyways. So she says, all right, with that stupid thing out of the way, now let's get to the gag order. She says, so here, it sounds like Jack Smith, the government, Biden's prosecutors, it says your order is seeking to limit Trump from saying things. And it's the same statement we read previously. So no social media posts from Trump, nothing that goes after credibility of witnesses and so on. And the judge is saying, well, I have this question over whether Gentile, the SCOTUS case allowing limits on attorneys is limited to attorneys. She's saying, well, under this case law, does this only apply to lawyers or does this apply to lawyers and the defendants? I'm not sure here. She says, well, there's a bunch of things that this proposed order that it does not prohibit. So she's saying, I'm reading this now, kind of commenting about it generally. And she's saying that Trump's conditions of release, they already require him to abide by the laws, obviously, right? So every time they come out and they say Trump is threatening and intimidating, or he's doing something like that, they're just making that up, right? He could be charged with threatening and intimidating. You can't just call up and threaten and harass people and encourage people to like eliminate other people, right? That type of stuff is not legal in most situations, if it's actually a crime. Trump posting that Jack Smith is a deranged thug is not that. But she's making this distinction here, right? Now they say it is. They say, well, it's stochastic terrorism. It is incitement in the aggregate. Each one of Trump's statements alone by in and of itself is not enough. But when you aggregate all of his truths together and plus all of his supporters, then it turns into this real dangerous threat and Jack Smith is now at risk. So she says he's already got to abide by the law. He doesn't have to do anything differently. So one is 18 U.S. Code. She says it prohibits attempts to interfere with witnesses. It's already illegal to do that. You can't interfere with witnesses. witnesses. There it is. You can't intimidate, you can't harass, 18 U.S. Code 1512. Now, as she says, as long as the witness is foreseeable, if we know what the witness is and Trump is actively trying to influence him, then he could violate the law, right? This is accurate from the judge. And she cites a D.C. Circuit ruling for that. And she says it sounds like Trump hasn't broken the law right now. So she goes to Molly, right? And this is what judges do. This is the Socratic method. They start asking questions of both sides. So she sits up there and she knows what she's doing anyways. And she turns over to Molly Gaston, highlighter girl, who said the defense doesn't even need to read the 8 to 12 Washington monuments worth of discovery because she organized the government's so-called theory of the case for the defense. Very nice of her, which again, the defense never cares about at all. It's a ridiculous thing. But she says, so Molly, so how is what you're asking for different than the conditions we've already set? Sounds like we're already protected under the U.S. Code. She says, well, Your Honor, there are two sources of prejudice that the government seeks to prevent. First, things that are derogatory, that are inflammatory, and they're intimidating statements that are attacking witnesses, and some of those types of statements are not covered by the law. So the law says that you can't incite or you can't intimidate or harass, but maybe there's derogatory language, there's inflammatory language, there's intimidating language that's not covered. She says, and those statements could still risk damage to the witnesses or other witnesses that see the attack. And she says, okay, so actual direct threats to people who are going to participate as witnesses, but also the trial of the case in public, false renditions of evidence, attacks on witnesses' credibility. Those are things that we want to protect against. So if Trump comes out and he has a different interpretation of the statement, he can't communicate about that in the court of public opinion. Okay, they want to keep this whole thing isolated into the court of law, where it's their favored little coliseum. They have the whole thing rigged with their jurors and everybody involved. And if Trump can speak about this, well, according to the government prosecutor, he'll be afforded the opportunity to provide a false rendition of the evidence. We should just listen to them because they're so good and honest with us. And also attacks on witnesses and statements. And the judge says, well, what do you mean about this intimidating statements quote? She says, Molly, set aside for a minute subjects of statements. How do you define disparaging and intimidating? And Molly says, well, I've got the dictionary right here, Your Honor. And she starts running through the dictionary. Disparaging is really offensive to government prosecutors, which is basically everything, by the way. It's the combination of these things, especially when we're talking about Trump, okay? If Trump orders a turkey sandwich, illegal, death penalty. There could be fair way to disparage somebody, she says. So it's a combination of these things. Some of these things are appropriate, some are not. And then the judge says, well, what do you mean, Molly? What do you mean fair? What does that mean? Asking the court to get involved in a variety of statements? You want me to police all the statements? Molly says, Your Honor, well, the standard here is this is limited to witnesses at this trial. Okay, now we have another question for ourselves. How broad is this order? Because we don't know who the witnesses are. This is the January 6th case. They were investigating this for like 3 years, man. And they said this was the biggest, most extensive investigation, blah, blah, blah. There are over 1,000 defendants who've been charged. They say there's another 1,000 in the queue if they get to them all. We've got tons of government officials, and so Trump is supposed to just limit his speech to every possible prospective witness in this entire case, in this entire arena. He can't comment on Bill Barr, for example. He can't comment on Milley. Can he not comment on Nancy Pelosi, who is on the phone calls, or anybody else who is involved? Is he just gagged from all of them? So let's see. She says, including statements intended to influence the trial. And so we're going to read Trump's mind now. Intended to influence the trial versus how about intended to respond to political corruption in the country, and he's running for president to solve that. Article in Washington Post by Trump's spokesman, they say, his intent is to try the case in the court of public opinion. Exactly what should not happen. Well, he's allowed to also communicate it in the court of public opinion. You guys can prosecute him in the court of law, and he should also be able to make his case in the court of public opinion. They're two parallel systems, and by the way, if the court of law is legitimate and trustworthy, and people believe in its credibility, there will be no difference in opinion. The court of public opinion will mirror the court of law because public opinion will mirror legitimacy. But they don't have legitimacy in the court of law, which is why they want to shut up the court of public opinion. So they say that this order is going to be narrowly tailored to accomplish that purpose. We're not wedded to these exact words, Your Honor. We know this is hard to gag your political opponents, but answer cannot be that defendant is permitted to intentionally try this case in the court of public opinion and influence influence the jury veneer, the pool. Well, he's not intending to do that, would be his argument. He's intending to run for president. You're deciding to prosecute him, and your criminal prosecution should not usurp all of the other interests in the country in having a fair election. So the judge says, well, what about if he's publicly praising a witness, Molly? So you said he can't disparage. What about the opposite? Well, she says that's what we're trying to get at in the paragraph 1A. You know, bolstering a witness is covered. And says, well, the order has a carve out for the judge to announce without more that the defendant denies the charges. That's it? Molly says it would allow the defendant to campaign. He could say, no, I didn't do the crimes and I acted appropriately. So they're saying Trump can deny the charges, right? According to your order. That's it? That's all he can do? That's all he can say? Like, that's it. He can just go on TV and say, I deny the charges. I deny the charges. But he can't talk about anything else? Well, it would allow him to campaign if he has that. So he could say, no, I didn't do the crimes and I acted appropriately. And she says, okay, so you're envisioning a different situation than currently exists. Is that right, Molly? Molly says he could say, no, I didn't do the crimes and I know I acted appropriately. Then she turns over to Trump's defense attorney. John Laurow's there. He stands up. Your Honor, I just want to say we're in a campaign right now. All right. We're dealing with content-based political speech. You're saying that he can't talk about certain content, not time or place or manner restrictions. You might say that you have free speech limitations. You see people protesting at certain locations. Time, place, and manner. We've said, oh, that's okay. You can't have a bullhorn at 2 a.m. at City Hall, but you can have a bullhorn at 2 p.m. at City Hall on Friday night or Saturday morning or whatever. But you can't limit what they say at City Hall. Say you can protest abortion, but you can't protest Iran, whatever. Here, it is exactly that. Trump cannot say certain things about certain people in the middle of a campaign. They say the Biden administration, Trump's lawyer, Your Honor, is trying to silence his primary opponent in the middle of an election. And Chutkan says, well, let me stop you right there, John. Mr. Trump is a criminal defendant, and he's subject to the same rules as everyone else. He says everyone's complying with the rules, Your Honor. The judge says, oh yeah? Skeptical. Everyone's complying? John says, here's what the prosecutors want. They want to prevent President Trump from speaking out on the issues of the day. The role of prosecutors, Your Honor, the appointment of judges, they all have political implications, and we have to talk about that. She said, well, hold off on a minute here. I want to make sure I'm clear on this recurrent theme here. All right, the fact is, he's running for president. It entitles him to make statements that are otherwise unlawful. He can make threats. Is that what she says? And obviously, do you see where she goes? She just jumped the shark on this thing, man. Threats? Nobody's claimed that he's made threats. In fact, the government hasn't even claimed that he's made threats. The government themselves acknowledged that if Trump made threats, it would have been brought under the U.S. code as a criminal code violation. It wasn't. So the order is made to prevent the things that are not threats. But then the judge says he can make threats. Trump's defense says, of course not, Your Honor. And he hasn't made threats. Well, Mr. Lauro, Trump has restraints on his speech, obviously. Do you disagree that those override his First Amendment rights in his campaign? He's subject to the conditions of his release. And John says, Your Honor, what we object to is the Biden administration attempting to censor his political opponent. Mr. Trump is entitled to speak truth to oppression, and he's entitled to criticize these prosecutors. And here we have a situation where the Biden administration, and she says, hey, look, John, I know you have a message you want to get out, but I don't want to hear any campaign rhetoric in my courtroom here. He says, campaign rhetoric? It's not campaign rhetoric, Your Honor. These prosecutors in this courtroom decided to bring this case in the middle of a campaign. They started it. They chose to have it inextricably intertwined with a political campaign. Trump, in the middle of that campaign, is here and entitled to say that these proceedings are unfair, and he's abided by your orders this entire time. And the judge, well, hang on a minute. I'm going to take issue with that statement right now. And Lauro continues, Your Honor, prosecutors haven't presented any evidence of a jury being tainted. Not at all. Not even one bit. So the easiest thing to do, if they're really concerned about that, with the jury being tainted, is putting this trial off until after the election. It wouldn't have to rush to judgment. We could put this whole thing past, and then we would know there's no harm to the jury. That's the way to deal with it, Your Honor. The judge says, absolutely not, okay? This trial is not going to yield to the election cycle. Very adamantly expressed. You hear me, John? This trial will not yield to the election cycle. Nah! Now, Molly, says the judge, now I want to ask you how this would work if I'm going to grant your order. All right, say I enter this order, which I'm about to, and Mr. Trump violates a restriction. What happens next? Revocation of supervised relief? arrests, home detention, contempt of court. This is literally asking Molly, what do you want? You want to jail him? How does it work? And Molly, the highlighter girl who says Trump doesn't even need to read the discovery and is not entitled to, says, Your Honor, all of the options you mentioned, as she's salivating, just dripping with glee, all of the options you mentioned are available to the court. You can put him on supervised home detention. You can hold him in contempt. You could throw him in jail and revoke his release conditions if you want. You could admonish him. You could pursue financial penalties. You could, like in the Stone case, modify his conditions of release. Make him check in with somebody. Make him give up his passport. Confine him to his local state. Put him on home detention. Whatever you want to do, Judge, you're allowed to do it. She says, well, I know that, but what about the procedural posture, right? If Trump goes on True Social, this is going to be something that we tap dance around this entire election, unless Trump just decides to start throwing elbows, political elbows, just dropping on Truth. Boom, 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 and see what Judge Chutkan does. And I almost want to see that. You know, I don't encourage anybody to ever violate a court order, but what we have here is the judge violating the free speech order of the First Amendment. And so now Trump has to gauge what to do about this. Now, his free speech rights are directly opposed to the process that you would expect to have in a criminal court. But this is not any ordinary criminal court, and this is not any ordinary criminal case. So if Trump drops a truth off, what are you going to do about it? Molly, what do you want me to do about it? Throw him in prison? What's the procedural posture? Do you want me to issue an order to show cause? The order to show cause, the judge is asking, do you want me to set a hearing so that we can come in here and argue about the specific statement? Or do you want me sua sponte on my own? Do you want the court to just find a violation, to just, Judge Chutkan sitting at home doing whatever, and she gets a truth notification pops up. Jack Smith is a deranged freak, signed Donald Trump. Oh, Trump's going to prison. Do we need a hearing on it, or do I just throw him in the gulags? Molly says, well, any of those, Your Honor. But that's a hypothetical. So I suggest we first get in place an order. So the government is telling the judge suggestions. Well, Your Honor, the judge should say, yeah, I know it's a hypothetical. That's why I asked it, because it's probably going to happen, and I need to figure out what to do about it. The judge doesn't ask that, of course, and she knows where she's going. She turns it back over to Trump's defense. Says, Mr. Lauro, assumed I issued an order. What would be the proper procedural posture for a violation? He says, Your Honor, it's asymmetrical, all right? It doesn't bar Joe Biden from making any statements, and she says Joe Biden's not before this court. So how to enforce this? It's impossible. It's unfathomable. Say he wants to criticize Vice President Mike Pence, who's running against him in this current campaign. Say he says something disparaging against Mike Pence in violation of what the government says he's not allowed to do. The judge says, well, were there an order? What's the procedural posture governing the enforcement? All right, which is just wild, because she asked the government a hypothetical. Just to be clear about it, you can see this very well in the transcript, the double standards that exist. Hey, Molly, what's the posture if Trump violates it? She says, I don't know, it's a hypothetical. So let's just get it done, because she knows it's going to happen. She just wants to get it through because it's going to be the rule that serves her side. Then the judge turns around and asks Trump to say what they would do if there's a violation. Lauro says, Your Honor, impossible. What's the posture governing enforcement? What do you think we should do? He says, impossible. I can't even conceive it. Obviously, we'd appeal it, but it's ridiculous to think of an order preventing a candidate from speaking out on these issues. No limits to the kind of order being suggested. It's just broad. You just can't criticize people. It's not narrowly tailored. It's vague. It's overbroad. You can't come up with a better template for violating the First Amendment than government prosecutors have come up here. There have been no threats, nothing at all that amounts to intimidation. And what you've put in place, Your Honor, right now is working, frankly. It's working right now. The judge laughs out loud. Yeah, right. It's working. Politics, she says, it stops at the courthouse door. She laughs at him. It's not working, right? She's cackling, probably like Kamala. Lauro says, Your Honor, the other thing, the harm being suggested by the prosecution or by the Biden administration here, it's completely speculative. Okay, there's no data about any of this. They're saying jury's going to be, biased or whatever. No data. It's all just them making it up. And she said, well, the government did file redacted info from people who attested to what happened to them. And there was another filing. And she says, that's not sufficient. And John says, no, of course not, Your Honor. All those documents predated this case. And Trump's not responsible for what some crazy third party does. So you can't blame Trump for that and gag him as a result. The judge says, well, my concern is the jury pool, the Biden administration and the DOJ and special counsel staff and judges staff and political witnesses. That's who I'm concerned about. Not Trump and his free speech, or all of the American citizens in this country who want to vote for him and want to hear from him. And he's not going to be able to talk about what I consider to be the biggest issue issue of our time, which is a wrecked judicial system. There is no law. There is no free speech if there's no justice system, no functional justice system, because everybody just dumps all over your rights. Biden comes in, oh, student loans, write those off, right? It's total madness, total disorder if there is no law and order. And everything that they're doing now is to wreck the institution. And they're doing it because they're freaked out about Donald Trump. And they're blaming him now for third-party actions. So now they discuss this Trump statement. So they say, well, let's pull up some examples, the judge says, right? She's probably got all these clips. She says, well, what about this statement, Mr. Lauro? Trump posted, no way I can get a fair trial, or even close to a fair trial in D.C. There are many reasons for this, but just one is that I'm calling for a federal takeover of this filthy and crime-ridden embarrassment to our nation, where murders have just shattered the all-time record, other violent crimes have never been worse, and tourists have fled the federal takeover. It's very unpopular with potential area jurors, but necessary for the greatness and for all the world to see. So the judge says, well, John, calling D.C. a filthy, crime-ridden embarrassment disparages the jury pool. Now, let's assume that these statements have affected the jury pool. Why can't these issues be addressed through jury selection, Molly? And remember, back during the, many trials we've covered here, they always ask the jurors. For example, in the Trump trials, they just allow the jurors on. They always ask the question, do you hate Donald Trump? Yes, I hate his guts. Oh, that's perfect. So you'll be a great juror for our case because it's against Donald Trump, so we love you. But just to make sure that, not a problem for the transcripts, can you set aside your absolute hatred for Trump and be a fair and impartial juror in this case? Can you? Can you? Yes. Yes, I can do that. Perfect. Come on in. So she says, why can't this be addressed through careful jury selection? So if the jury is impacted, you ask about it and say, can you set that aside? The judge says, Mr. Lauro, do you disagree that Mr. Trump's statements could be understood as disparaging to D.C.? He says, Your Honor, Trump is disparaging the Biden administration. But that's not what he said. He called the district, that's my district, a filthy crime-ridden embarrassment. John says, I served in D.C. The judge says, before it was a filthy crime-ridden embarrassment? They all laugh. Your Honor, look, Mr. Trump is entitled to speak out, okay? He's entitled to draw attention to deep problems in this city that need to be addressed, but that have not been addressed by Biden. And plus, these statements, if they had any effect, jurors would likely be biased against Trump, not for him. And isn't that the problem with censorship? The judge says, Lauro, you keep saying censorship, okay? No question that the court is entitled to impose limits on defendant's speech. So she doesn't like being called a censor, which is perfect for the thumbnail that we created today. Says, we're talking about restrictions to ensure a fair trial. And he says, sorry, you don't like the word, Your Honor. It is censorship. Would you rather I call it a gag order? It's speech during a political campaign that you say that I can't talk about. And she says, well, if I enter the order, he can say that Biden has neglected the city, right? That's different from saying it's filthy and a crime-ridden embarrassment. So Trump can't call D.C. a filthy crime-ridden embarrassment because it offends the judge. So now we're going to have a judge directed the words a candidate can use, Trump's defense. So you're going to tell our client what he's allowed to say now? She says, well, it's not a difficult or impossible task for me to do that or for him to talk that way. So you're saying, Judge, that a candidate cannot say D.C. is a crime-ridden, infested rat hole, even though we know that's true? Everyone in the city knows it's true. It's what's happened in recent years. Molly says, Your Honor, what Lauro is saying is that Trump is above the law, not subject to the rules of this court like any other defendant. Oh, gosh. Everybody can picture this, right? Everybody knows this student that you had in grade school who stood up and talked like this, So she's in the process of gagging Trump, and they literally can't even talk about what a dumpster fire D.C. is. And Molly, Your Honor, he's saying that Trump's above the law. Now, he says the defendant can't campaign, but that's just not true. This order would prevent him from using the campaign to broadcast improper statements about this case. And the post you just quoted was attacking the jury pool in this case. It explicitly says it's about this trial. Chutkan says, calm down, Molly. I know that I'm going to vote for you anyways, but I want to get through all the 5 categories. So let me ask you about the other statements that the Biden administration and the DOJ are involved in that we have some concerns about. She says that Mr. Trump repeatedly, she's pulling up another statement, and they're talking about what Trump's allowed to say or not. Unbelievable. Says in this statement, Mr. Trump, this is the judge speaking, repeatedly refers to president as crooked Joe Biden and the Department of Injustice, which they don't like. But wouldn't that be casting a broad net? How would name calling affect the administration of justice? How would Trump saying Department of Injustice affect us? And they really hate this, okay? They really think, like these people, they love this institution so much they can't imagine that they're on the bad team and all of this. They think everything they do is justice by virtue of the fact that they work in a building called the Department of Justice. But that's really the depth of their understanding of justice or what they're actually working working to under the United States Constitution. And so when you call them names like this, they can't take it, man. They can't take it. It's like cognitive dissonance, because they wake up every day and they look at their badge and they're like, I'm doing justice. You're like, oh, really? By prosecuting people that the FBI set up? Congratulations. So they say, wouldn't that be casting a broad net? How would the name calling affect the administration of justice? Molly says, well, Your Honor, the first part here is criticizing Biden is an example of how this order doesn't restrict the order. She says, well, does crooked Joe Biden violate your order? Well, he says it every day. The judge says, so Molly, so does it violate it? Yes or no? No. What about if he says the Department of Injustice? Can he say that word, Molly? Hall monitor Molly? It does present a concern that the juror will think that the DOJ is unjust. Do you hear this? Molly doesn't want you to call it the Department of Injustice because potential jurors will think it is unjust. Well, we're going to keep calling it that indefinitely here every stinking day on the show, indefinitely. So Molly continues. She says, our concern is not to defend ourselves or the court. It's a concern that jurors will come to jury selection and not be able to follow the court's instructions because of having read these things. These are Washington, D.C. jurors that are like 95% blue anyways, okay? They are coming to eliminate Trump as hard, as quickly as possible. She says that this case law stands for the principle that we just can't let these things happen up until the time of voir dire, which is jury selection. So she says, okay, Molly, so crooked Joe Biden is not a violation according to you, but Department of Injustice, if he tweets it, that would be illegal. So a presidential candidate who's running to control the Department of Justice can't comment on the department being currently bad, as being unjust. Says, well, he can criticize Biden to his heart's content, says Molly. She's not answering the question according to this transcript. Chutkan says, so Mr. Trump believes his prosecution is politically motivated, but how does that prejudice this proceeding? It seems close to his right to assert his innocence and to criticize the government's use of power, which they say that we can get close to doing that. Well, she says, well, if Trump has a problem with this prosecution, he can file a vindictive or a selective prosecution motion that he wants to file. So he doesn't get to talk about it in the court of public opinion because he can file something in the court of law, which again is what they control in Washington, D.C. So he can complain about all of this directly to the judge, the same judge who refused to recuse herself, even though she has some very interesting history and some conflicts for working with other interesting law firms. So the judge says, well, but how does his criticism of the Biden and the DOJ factor in if I enter this order? Molly says, well, the crooked Joe thing, okay, he's not a participant in this case, so he can definitely call his political opponent crooked Joe Biden. Oh, good. Molly is allowing Trump to criticize his political opponent in America. Incredible. Trump's defense says, Your Honor, well, what if Trump says something like, crooked Joe Biden approved this prosecution, which I believe is a politically motivated witch hunt to interfere with the election? Can he say that? Molly says, oh, yes, Your Honor, that violates the order, okay? Falsely suggesting Biden directed this prosecution, which he did not. And I don't believe that for a minute, okay? That is a fact, not an evidence, Molly. I think we can prove that very differently. Joe Biden was upset as heck when Merrick Garland did not have the gas pedal pushed against Trump. This is outrageous, just to be clear with you, okay? Trump should absolutely be able to say this. Absolutely. Because there's actual documented evidence about this, that Joe Biden, I think the Washington Post wrote about this, talking about Joe Biden being upset that Merrick Garland was not taking a more active involvement in going after Trump and the documents specifically. So Joe Biden runs the DOJ, and Merrick Garland has appointed the special counsel, and Joe Biden appointed Merrick Garland, right? So the judge says, well, the problem is the argument to be made that the DOJ is under control of the executive branch, okay, that's true, like factually. It's part of a campaign, so that violates the gag order. So Trump literally can't talk about the Department of Justice, which is the entity that he wants to run soon. Well, she says, if we enter this order by the plain language of the order, it would violate that order because Joe Biden is not a party. It would not violate the order because Joe Biden is not a party, participant, or court personnel. It says, and John Lauro comes back out and says, Your Honor, they have to read their own papers before they respond to the court, right? Saying she doesn't even know what she's talking about according to her own order. She says, what if Trump says Hunter Biden is allowed to sue witnesses and allowed to talk and I'm not? Can he say that? He says, Your Honor, we're just trying to struggle with the circumstances of what's being proposed here. I'm thinking George Orwell would have a field day with what we're hearing from these prosecutors here. That's John Lauro saying. And Judge scoffs that off, moves on. All right, now I want to move on to the third category. All right, so we still don't know what the details are on that. What can Trump say? What can Trump not say? The judge is just going through it. And it's just crazy to me that the government prosecutors are saying that a presidential candidate who's running to run the DOJ can't comment on a corrupt DOJ. So the judge moves on to the third category. Can Trump talk about deranged Jack Smith? Trump refers to him and his staff staff as thugs. Now, the judge says, oh gosh, I love Jack Smith. Now, these statements are troubling. At some point, it goes from permissible criticism to incitement of violence. She says this quote, will no one rid me of this meddlesome priest, comes to mind. Says public servants doing their job, not just derogatory language and labels, but highly charged language. So you can't call Jack Smith a thug because they're prosecuting you like mobsters. Will one rid me of this meddlesome priest, which is not what Trump said at all. He didn't say rid me of anything like that. But Jack Smith and the Democrat prosecutors, the people who have a bloodlust to throw J6ers in the gulags when they just look the other way at all of the other riots and protests, they are thugs, in my humble opinion. So the judge doesn't like that language. And the defense continues, says, Your Honor, I'm sorry that you don't like the language. Congressman Ford called his prosecutors racists, and the Sixth Circuit upheld that, okay? So you can say things like that when you want to. And by the way, my client, Donald Trump, is being bullied. I think he said Jack Smith is deranged. He made outrageous statements at the time of the indictment, linking Trump to violence. And so Trump was responding to that, and he is deranged if he thinks Trump is engaged in violence. In what kind of case is it appropriate for a criminal defendant to call a prosecutor a thug and to stay on the streets? And he says, well, whether it's the language I would use, says, I'm asking in a normal prosecution, would a defendant be allowed to call a prosecutor a thug? He says, this is not a normal case, which I absolutely agree with. And by the way, right, in a normal prosecution, I don't think a judge would allow it, but that's because in a normal prosecution, that person is not running to run the prosecutor's office, okay? But if they were, I think that would absolutely be allowed. Why? Because it's relevant to the actual prosecution. He says, this is not a normal case. In fact, this is a prosecution unprecedented. It's using statutes in all sorts of crazy ways. It's trying to take Trump out of the political cycle. So asking for an order, not just affecting Trump, but also the public that wants to hear from Trump. This is the first time we've ever in America's 234 years had a sitting administration prosecute a political opponent. And the judge is like, gosh, John, I've heard you say that, okay? You obviously have an audience other than me. Trump's listening. I want you to answer my question. Why do you need to use the word thug to describe someone doing their job that wouldn't be allowed with any other defendant? How is the word thug justified? Well, it's justified because it's free speech. She says it risks a real possibility of violence. He says it doesn't do that. What language do you use in a system that's now bordering on authoritarianism? What else do you call him? What is a citizen supposed to say when he's being denied due process? In President Trump's mind, that's what he's facing right now. And she says, well, he tweeted something last night, John. He's in Iowa today campaigning. And she says, hey, John, Mr. Lauro, let's tone this down a bit, okay? Stop screaming at me. Let me just wreck your client's constitutional rights in silence, all right? Stop getting so riled up. John Laurel says, Your Honor, it is toned down, all right? As an advocate, I'm entitled to make my arguments on behalf of my client. If you, Judge Chutkan, if you want to censor me too, the word Trump chose may not be the word you like, but he's entitled to make that statement under these circumstances. And he says, John, he's targeted special counsel Smith's family and his wife. He says, no, he didn't. It wasn't an attack on a family member. By mentioning their spouse, says the judge. Well, he says it deals with political issues that relate to Smith. And says, so no order in place preventing him from saying this is politically biased. No order in place preventing him from saying this is politically biased prosecution by a politically biased prosecutor. So the judge says, what do you feel is appropriate for him to talk about a prosecutor's family and spouse? You're telling me it's appropriate and he should be allowed to talk about that? Yeah, he's entitled to, under the First Amendment, describe it. She says, what, in unfettered terms? He can even mention a prosecutor's family? He says, yes, Your Honor, it's part and parcel of the First Amendment. It's the part of the reality of being involved in a case of this nature. And Molly chimes in, says, Your Honor, I think you identified right here why the government is asking for this. You nailed it. You hit it right on the head, she says. Great job. We pair disparaging with inflammatory together. They can't figure Trump out, right? They can't respond to him. They can't run a candidate against him. They can't indict him enough. They can't impeach him enough. They can't, Marco Rubio, small hands, big hands thing, and they can't figure him out. So now they're just saying, well, this speech, you got a disparaging and inflammatory. Like, you see how twisting they are themselves into pretzels? When they're doing this, you know what's at stake here? The First Amendment. They are going through all of this new novel conversation because they cannot figure out how to shut him up. So they say we're comparing disparaging and inflammatory. What the defendant is doing is inflammatory. He understands the impact. They motivate others to threaten others. Trump says something something and other people do something, so he's responsible. In this case, it threatens witnesses and it chills witnesses. And when he gave a Meet the Press interview, he said false things about one of the witnesses in this case. So when he was on cable news talking about this case, he was saying things that the government didn't like, so he should be silenced. And he also declined to answer certain things, and he declined to answer questions about his conduct. So he's able to control himself, but he's using his campaign to try this case in the court of public opinion, which, is there a prohibition against that when you're running for office? So the judge says, all right, well, now I want to turn to his statements about the court. I pulled this one up. The judge has her whole binder there. It says, I was deeply disturbed to learn that Mr. Trump made a post about another judge's clerk, and he even called her Chuck Schumer's girlfriend, said that she was running the case against me. John, Trump's defense, do you find this post acceptable? And this was posted back on August 8th. Says the Obama-appointed judge in the free speech indictment of me by my political opponent, crooked Joe Biden's Department of Injustice, shared professional ties at the law firm that worked for Burisma, based in Ukraine, of which Hunter Biden and his associate were proud members of the board and were paid millions of dollars, even though Hunter knew almost nothing about energy. How much was the law firm paid? So horrible. This is a classic conflict of interest gateway pundit saying the Obama-appointed judge in the free speech indictment of me by Biden. So this is about Chutkan, or this is about the judge in New York. I think it's about Chutkan. Let's continue. Let's see where this goes. So Lauro says that is something I believe the judge in New York dealt with. Says, well, I'm not asking that. Well, says I'd advise Mr. Trump to do that. Okay, so the judge, okay, so here's why we're a little bit confused. This statement was about the New York judge. This statement was about Chutkan. Okay, Trump is also being prosecuted by Letitia Tishy James out of New York in a civil case trying to take away his businesses. And in that case, the judge, Engeron, had somebody who was in his ear the whole trial, just, barking orders in his ear. And Trump called her out. This is a different truth about Judge Chutkan. So the response here is to the first situation in New York. Well, I'd advise Trump not to make comments about clerks. Well, would it be appropriate to do that? What I'd tell my client is not to do that. Well, why would you tell him not to do that? Because that's not how in the middle of a campaign, in the middle of a case, he says, Your Honor, it was addressed by that judge. But yes, judges are subject to criticism, okay? So he can. It's well within the core of the First Amendment. You can see he was going to kind of agree that maybe he was crossing the line a little bit, but nope, he goes back to First Amendment. Nope, which is the right answer. First Amendment, he's allowed to do it. Because again, it's parallel. It's not appropriate maybe in a criminal courtroom or a criminal case, but he's also running for president and he's being prosecuted by his political opponents, okay? That's why the First Amendment comes before due process in the Fifth or Sixth and right to counsel and these other things. It is first, man. It is first. And it's defended by the Second. It comes before everything else because that's how you expose the corruption. So here it was addressed by that judge and says, why shouldn't I then issue a similar order like Judge Engeron did in that case in New York, disparaging and obviously untrue remarks about court personnel even after he was on notice that the government was seeking the order in this case. And Lauro says, Your Honor, there's no need for an order. If Your Honor makes that admonition, he'll follow it, okay? He won't say anything bad about your staff. How about that? I will instruct my client along with what you suggested. The court dealt with it in New York. It's done in New York. It's not even an issue here. So you don't need to, on your own, just create a structure for an issue that's not even popped up yet. Said, you've had full control over this court, Judge. Trump's defense. Chutkan, you're doing a great job. Nothing's wrong here. New York was a little bit squirrely, but we're not there here. You've been able to issue orders that have been followed and obeyed. And the other cases are nothing like what's going on here. Your Honor is in great control here. Molly stands up. Oh, Judge, don't listen to John, okay? Lauro suggests nothing like what happened in New York has happened here, but that's not true. This case has been subject of a criminal threat in relation to this case. This court has been the subject of a criminal threat in relation to this case. I don't know, was that Trump's threat? Why didn't you charge him with a crime then? So we're happy to have Lauro admonish his client. That's great. You can talk to your client, but we also need an order. We need an order expressing on the record what the court order is, not what the expectation is. And the judge says, well, I'm going to think about all of it. So thanks for your arguments. Now here, I want to talk about this other case. What about these other posts about other witnesses? For example, this one. Judge pulls this one out of the binder. Says, wow, from Trump, posted this on Truth on August 5th. Wow, it's finally happened. Little Mike Pence, a man who was about to be ousted as governor of Indiana until I came along along and made him VP, has gone to the dark side. I never told a newly emboldened, not based on his 2% poll numbers, Pence to put me above the Constitution, or that Mike was, quote, too honest. He's delusional, and now he wants to show he's a tough guy. I once read a major magazine article on Mike. It said he was not a very good person. I was surprised, but the article was right. Sad! So they talk about this. Well, how about this one about Mark Milley? Trump posted this September 22nd, 2023, a recent one. It says Mark Milley, who led perhaps the most embarrassing moment in American history with his grossly incompetent implementation of the withdrawal from Afghanistan costing many lives, leaving behind hundreds of American citizens, and handing over billions of dollars of the finest military equipment ever made, will be leaving the military next week. Witness, VP Pence witness, Milley witness. This will be a time for all citizens of the USA to celebrate. The guy turned out to be a woke train wreck who, if the fake news reporting is correct, was actually dealing with China to give them a heads up on the thinking of the President of the United States. This is an act so egregious that in times gone by, the punishment would have been elimination. A war between China and the United States could have been the result of this treasonous act, to be continued. So the judge brings that one up. Now she brings up the other one about Brad Raffensperger, the Georgia Secretary of State. And she says, all right, well, now I want to start with the witnesses who are identified but who are public figures, saying, look, I take your point, all right? It's impossible, this is Chutkan, for Trump not to criticize Pence, who's running. But none of the other people fit this description. So what about the other people who are not running? Well, Lauro, Trump's defense says, well, the government had an opportunity to go get affidavits from Milley and Raffensperger and Barr. They could go get affidavits from them. Well, why should they have to? Well, all those men have publicly criticized Trump, so he can give it as good as the get. So if they criticize him, he can criticize them back. He says, really? Trump suggested that Milley should be eliminated? And Lauro says, well, Milley was terrible, and he did this, and Milley did this, and so Trump had reason to criticize him. And the judge says, punishable by death? What Milley did was the sort of conduct by the head of the Joint Chiefs of Staff going around civilian leadership and speaking to China. Well, why is it appropriate to suggest the appropriate punishment is death, writing in all caps, death? Doesn't that go too far? Trump's defense says, well, it's still true that the death penalty for treason is available. If you commit treason, the penalty is death. He went behind Trump's back, talked to China. So it's factually true, Judge. It's not inciting anything. And she says, well, that's right up there. Will no one rid me of this meddlesome priest? Millions of followers, and so someone may have acted on it. Lauro says, you hit the nail on the head, Judge. Exactly right. Someone took a shot at Representative Scalise. Are we going to say that political figures can't give speeches? We're in the zone of clear First Amendment political speech, even though there's criminal prosecutions going on. Under the Brandenburg standard, none of what Trump said incites anything. Molly stands up with her highlighters twirling around, says, Your Honor, we both know that we know about the post-Milley. We know it was a threat. It was a threat to Milley and to all witnesses. It was a threat. It says, if you come after the defendant, Trump's going to come after you. And Molly starts defending Milley's actions. She's like, Mark Milley's an American hero, okay? He stood up for American values when Donald Trump was screaming around, attacking the Capitol and breaking clavicles all over the Secret Service cars. Judge cuts her off. Molly, calm down here. I agree with you, but calm down. All right, we're not talking about Mark Milley and how much you love him. Relax. Says, okay, what response here, Molly, to L's criticism? What about respond to them that you didn't provide affidavits? You could have gone and just gotten statements from them. And she says, well, of course, prejudice is speculative. It may be chilled in some ways that we don't know about. But the post about Raffensperger also misstated what Raffensperger said. And it was about the exact topic that Raffensperger was supposed to testify about. Says, the judge speaking, because it concerns the subject matter of the testimony, that testimony should happen in the courtroom, but not in public. And says, Trump is not campaigning against Barr or Raffensperger or General Milley. So defense, why should he be making statements about them at all? Why should Trump be commenting about Milley or Barr or Raffensperger? All three major political figures that are going to be the subject of the 2024 election. That's why. He doesn't get to respond to every statement about him by a witness, says the judge. So they all get to talk and attack him, but he can't attack them back. Insane. Lauro says, Your Honor, with respect to Bill Barr, Trump is entitled to describe what he'd like in an attorney general. He can compare what Bill Barr did with an attorney general and what he'd like them to do. And the judge says, well, no one has said that he can't campaign or respond to criticism. What we're talking about is the language he's using. And he can't use words that can be interpreted as threats or attempts to intimidate. And Lauro says, oh my gosh, Judge, it is obvious that none of these are threats. He's already not said anything that's a threat. And she says, well, I don't think that's obvious, John. And she says, well, okay, so President Trump uses forceful language. I got that. But that's what he's done since 2015. He's entitled to say things that are critical of other people and other officials in the political political sphere. If anything, this district is biased against Trump as a result of the J6 hearings. And so we're going to be litigating ad infinitum all these issues instead of this case. All right, we've got a trial coming up, and you've already given us like 12 Washington monuments full of reading. And so instead of these angels on a pin discussion, here's one simple solution. Let's have this trial after the election and just solve this problem. The judge, for obviously not doing that, I screamed at you about this earlier. When Trump has singled out certain people in the past, hasn't that led to them being threatened and harassed, the judge says? And he says, well, that's totally irrelevant. Doesn't matter if other people have gotten threatened and harassed in the past. It's irrelevant. But these people, says the judge, were just doing their jobs. Several people who filed affidavits said statements threatening them had increased precipitously. And those people are public officials. Election poll workers, says the judge. Look, no suggestion here that Trump has ever done anything that amounts to a threat or incitement. You guys aren't even making that argument on your own. People just can't control what other people are going to do. Otherwise, the First Amendment will be excised out of the Constitution. If we're all responsible for everybody else's actions based on some loose connection to something we say, nobody can say anything, right? We're all going to be like liable for everything. So we have to tolerate a bit, they say, of colorful, vituperative speech. And the judge says, we have to tolerate suggestions of violence. Is that what you're saying? Molly stands up again with her highlighters. Your Honor, Mr. Lauro is saying that his client is above the law. He can say whatever he wants about this case. The statements about Milley, about Barr, about Raffensperger, we're all about this case. He's not campaigning. He's trying to pollute the jury pool, and the court has an obligation to stop it. Judge says, well, let me think about this. John, for the defense, I have a couple hypotheticals for you. Here's a question. What happens if somebody says this? Bill Barr should be executed for his treasonous acts. Is that lawful under the conditions of release and permissible? John says, Your Honor, look, I'd advise anyone to not make a statement like that. Why? Well, I personally, as an officer of the court, but why? She says, well, I don't personally think statements like that need to be made in the context of a court proceeding. Judge says, well, I have another hypo. What if this statement comes out, says, quote, I hope Bill Barr stays loyal to me, or he won't have a place in my next administration. Would that be permissible? Or would that be an attempt to influence the testimony? John says, well, just another hypothetical here. She's not giving many of these to the government. Says here it's a political statement because it's about trying to get his support in the campaign. So that's fair too. How about a next one? Bill Barr's a smart guy, but better learn to keep his mouth shut. Well, she says it depends on the context, Your Honor. If it's related to him, Barr arguing Trump and calling him out, that's a fair comment. But if it was the day before trial and Bill Barr is scheduled to be a witness on day 2 of trial, that's a different hypothetical, Judge. She says, well, how about this one? It's like a board game or something. Bill Barr is a slimy liar and can't be trusted. Is that permissible? The defense says, I'm not going to say truth is a defense. Oh! That's a zinger right there. Oh, man. Okay, so just to break that down, I wonder how that went over in court. Oh, I love it. So the judge says, hey, Bill Barr's a slimy lawyer and can't be trusted. So I'm not going to say truth is a defense, right? Well, it's true, and truth is a defense. But President Trump is allowed to comment on Barr's activity as AG. Bill Barr's a tough guy, Judge, okay? He can handle it. Says, Your Honor, look, I know you're protecting these people, okay? But these are tough-edged political people, okay? Bill Barr, Mike Pence, Milley, Raffensperger. They used to rough and tumble. They're used to this. They signed up for it. They're all monetizing their relationship, all right? They're going to write books about Trump attacking me. Do you think anything Trump said prevented them from writing their books? No. If Your Honor wants to have me show President Trump what your expectations are, I'm happy to show him. But Molly says, I'm going to run through your examples, Your Honor. Ask me the questions. Again, she's the hall monitor, okay? She stands up, and you remember her from grade school, like 4th grade. You remember her. Oh, gosh. Says here, about Barr being executed. The defendant should definitely not be able to do that. It is definitely intimidating and threatening toward a known witness, and it could chill testimony and those of others watching. I hope he stays loyal. That's also intimidating. It impinges upon the content of the testimony. And a smart guy but needs to keep it, also intimidating. And slimy lawyer, also, it goes to the credibility. And all these statements involve the details of testimony. And so Mr. Lauro wants you to just tell him, and he related it to Trump, so it won't be enforceable, but we need an enforceable order to stop this. And says, okay, well, listen, Molly, tell me about your universe of prospective witnesses. How many other witnesses are out there that you say are going to be possibly in this case that Trump can't comment about? Says, witnesses whom the defendant Trump has publicly attacked are all identifiable in the indictment. He knows they're witnesses, and in the conditions of release, there's a requirement that he not contact any witnesses based on the discovery that we've provided. Defense says, Your Honor, courts have also recognized recognized that parties to a lawsuit involved in political campaigns are supposed to be treated differently. Courts recognize that in the Ford and Brown case, Bill Barr is not prevented from speaking out. She says, well, Barr's not a criminal defendant. No, but the court will be regulating campaign speech if you say we can't respond to him. And no court has ever done that. This would be the first time in American history, which of course is appropriate because we're breaking glass all over the country right now. You've asked pointed hypotheticals, but it's not a law school question, Your Honor. What if he says something on the campaign? Are we going to be back here for a contempt hearing? We're in here because he keeps calling prosecutors thugs and deranged, says the judge. He's made comments about court staff and about the death penalty for a potential witness. That's why we're here. And he made statements all the way as recently as last night. And the defense says, Your Honor, that's true. Every single thing he said is protected by the First Amendment. Sorry you don't like that. Molly stands up. She says, first of all, the Ford case, court entered what the Sixth Circuit called a broad order, and it did it sua sponte, and it doesn't apply here. And with respect to another case, that's a cautionary tale. The court lifted an order soon thereafter, and the defendant started leaking stuff all over the place. And a new order had to be entered, and so don't follow that case because it turned out bad. I'm going to take a brief recess. She leaves. All rise. Oh, gosh. All right, Judge. Gosh. And the judge is back on the bench. She says, all right. Now, I've been doing a lot of thinking here. And after this hearing concludes, I will issue an order setting forth my decision in greater detail. But here's the gist of it. I've heard all the evidence here today in my courtroom, and I've decided I am going to grant in part and deny in part the motion to restrict out-of-court statements. Explaining her decision, saying, here, Trump has sought to represent that every statement that he's made has been part and parcel of his argument that the administration, the Bidens, are prosecuting his opponent protected by the First Amendment. But the judge says, but there is a right to restrict language that threatens the administration of justice. And so I won't impose limits on statements about Washington, D.C., so we can still call it a crap hole, but I will consider that in jury selection. And I'm not going to restrict statements about Biden or the DOJ, but I will prohibit all parties from making or reposting statements targeting Jack Smith, his staff, my staff, court personnel. Statements targeting family of these people are also prohibited as well. Trump can't call prosecutors deranged or thugs. So we'll continue to do that here for deranged, thuggish Jack Smith. Might put that on a t-shirt. Can't vilify or incite violence against public officials, which was already illegal to incite violence. Okay, vilify, call them thugs, whatever. So we'll see if she clarifies that in her order. She says, I'm also going to bar statements about witnesses or substance of expected testimony. Okay, so we don't even know what that is. It says there is a real risk that witnesses may be intimidated and other witnesses may be reluctant to go forward. Bar statements about witnesses or the substance of expected testimony, which again, witnesses are probably in the dozens, if not hundreds, of prospective potential witnesses, and the substance of what they say could be anything, right? So you saw how the hula hoop went very small. The order was very narrow and it just got monstrous huge. All right. So Trump, he can talk about DOJ, Biden admin. He can't talk about special counsel, very narrow staff, blah, blah, blah. Can't call prosecutors deranged or thugs, very narrow. Can't vilify or incite violence, already illegal to incite violence. But then, boom, all statements, all substance. There's a real risk that somebody may be intimidated. Now, Trump can assert his belief that this prosecution is politically motivated, but he can't launch a smear campaign against the participants in this case. I don't know how she is going to define that. I don't even know. No other criminal defendant can do that, and he can't either. He can't launch a smear campaign, which is really just a political campaign, isn't it? He's just running to say that the DOJ is corrupt and broken, which is what happens every political cycle. Everybody runs and says the government is corrupt and broken. In fact, we're allowed to petition our government for a redress of grievances, which includes calling out their incompetence. Trump is not running a smear campaign. It's a political campaign. If another criminal defendant is running a political campaign, they too can criticize the political institution that is prosecuting them. But Trump can't in this case. If a participant violates this order, I'll entertain motions by the parties, or sua sponte, on my own, the court voluntarily, without anybody prompting the judge, I will consider sanctions, which can include whatever she wants, right? Home detention, turn in his passport, contempt of court, go directly to jail, whatever they want to do. And Trump cannot speak because this is Washington, D.C. This is a corrupt prosecution of a political opponent. Court is adjourned. Boom! Judge enters, exits. So we get the conclusion from Roger Parloff at R Parloff. A great summary. If you want to give him a follow, follow. Encourage you to do that. He is reporting over for Lawfare, and they do great work, and we're grateful for the report. But my friends, a very dangerous order and decision from Judge Chutkan. Trump responded to it. We'll cover that next in our next segment, but make sure that you're here joining us as we continue to investigate this and follow this case well into the future. Thank you for subscribing and joining us by clicking the like button, and we'll see you as we carry on.